Hello, this video is part of an assignment for the Humber College Paralegal Studies program on the subject of Canadian immigration and refugee law. My name is Paul Commissar, and my peers in this project are Angela McCree, Jeffrey Curtis, and Christian Submersion. This video discusses many aspects of removal orders and appeals, primarily on the basis of humanitarian and compassionate grounds. We'll also touch on family sponsorships and judicial reviews of rejected appeals from the Immigration and Refugee Board. We'll relate all the topics together with a hypothetical scenario of a foreign national who faces deportation, starting with how they may have gotten into this situation, and going through the steps of what they may do from there to legally remain in Canada. Lin Pei-shen is a 30-year-old single mother and a Chinese national from Taixing, Jiangsu province. She works part-time in Ajax and lives with the entire Canadian wing of her family in the same house in Scarborough. She faces deportation after unknowingly failing to disclose that she has a child in China and as a result failed to acquire the required medical examination for those who have recently given birth. The facts of the case are undisputed, but Ms. Pei-shen wishes to appeal the deportation on humanitarian and compassionate grounds. Lin's 5-year-old son, Song Pei-shen, lives in China with Lin's brother and sister-in-law and their children. Lin and the family send Song's caretakers money occasionally, but the arrangements can't last much longer. If Lin remains in Canada, she will do everything she can to bring her son to Canada and obtain citizenship. If she is deported, she will not be able to live with her brother and sister-in-law for long, and she will have to live alone with her son, which she fears she can't afford to do. Her deportation will also disrupt the relationship she built with her nieces and nephews, and will be a major step back in her family's goal to move everyone to Canada. This all began after Lin became eligible for a family sponsorship. But what is a family sponsorship? Family sponsorships occur when individuals sponsor their spouses or eligible family members to come to Canada. These individuals can live, study, and work in Canada if they become permanent residents. Canadians can sponsor certain family members to come to Canada as long as they meet the following requirements. 1. They are a minimum 18 years old, are a Canadian citizen, or a person registered in Canada as an Indian under the Canadian Indian Act, or a permanent resident of Canada. 2. They are a spouse, partner, child, or only living family member left. 3. Are able to prove the sponsoree is not receiving social assistance for reasons other than a disability. 4. Have enough income to provide for the needs of any children of the principal applicant. A side note is that Quebec has an additional set of conditions that must be also met to become a sponsor. Lin had several family members who met these requirements and wanted to sponsor her themselves. However, candidates are disqualified from becoming a sponsor if they have failed to pay immigration loans or performance bonds or family support payments. They are also disqualified if they have failed to provide for the needs of a previously sponsored relative who received social assistance or are in a penitentiary, jail, or prison. Some of Lin's family members took assistance loans to help support the initial cost of settling recently arrived family members, and the one family member who finished off all their payments filed the sponsorship. These are the 5 steps in the application process. You can pause this video if you are watching this on your own to read the steps. Another side note is that it is also possible to withdraw an application, and the process is much like filing a follow-up application. It's more important to note that there are some rules attached to the extent of a refund you can retrieve, and that if the withdrawal submission is made too late, the sponsor cannot revoke the sponsoree's permanent residency and will remain responsible for the sponsored. The sponsored relative must also file their own paperwork. Lin does not speak English, and so her friend assisted her with the paperwork. The friend failed to notice that Lin had to declare her 1-year-old son at the time, which resulted in her failing to file a required medical examination for those who have recently given birth. Lin arrived in Canada not knowing that she could have brought and declared her son at the airport, and so she left without him, resolving that she would establish herself in Canada and bring him on a later date. Immigration eventually learned of Lin Pei-shen's failure to disclose her medical record and her son, and decided that she was inadmissible in Canada, They made a removal order against her shortly after. But what is a removal order? Visa-Place Immigration defines removal orders as an order issued when someone is convicted of breaching the Immigration and Refugee Protection Act in Canada. If you have committed a crime or are in Canada fraudulently, you could be issued a removal order. The Canada Border Services Agency is responsible for carrying out removal orders. Part 13, Division 1 of the IRPA governs removal orders. There are 3 types of removal orders: departure orders, exclusion orders, and deportation orders. The most forgiving of the 3 orders is a departure order. A foreign national faced with a departure order must leave Canada within 30 days and confirm departure with the Canadian Border Services Agency while leaving. If the rules of the departure order are followed properly, the foreign national may file an authorization to return to Canada. Next is the exclusion order. Those with this order are barred from returning to Canada for 1 year. If the order was given for misrepresentation, then the period is 5 years. If the CBSA paid for your removal, you must repay the fee. When this period is over, you may file an ARC. A deportation order permanently bars a foreign national from returning to Canada unless an ARC is filed. If the CBSA paid for your removal, you must also repay the fee. Ms. Peichen was issued a deportation order, and the ARC will be her last resort if she cannot successfully appeal the removal order. If someone does not attend their removal interview or scheduled removal date, the CBSA can detain a person until the earliest convenient opportunity for deportation. If a foreign national with a departure order fails to leave after 30 days, not only will there be a warrant for their arrest, their departure order will become a deportation order. A CBSA officer can make a warrant on a permanent resident or a foreign national if they believe on reasonable grounds that the individual is not admissible under the IRPA and may be a threat to the public, or may not attend a required appearance at any stage before a removal order, or will fail to obey a removal order, or can't prove their identity to a border security officer, or they constitute an irregular arrival. As an aside, the Government of Canada website also notes that immigration law allows for the arrest and detention of foreign nationals without a warrant. However, all are guaranteed rights under the Canadian Charter of Rights and Freedoms. For example, the officer must explain the reasons for the arrest, the rights to legal representation, and rights to notify a representative of their governments that they were arrested. There are also valid reasons to delay a removal order from being enforced quickly. Any appeal of the order or any ongoing legal proceeding can delay the order's enforcement. A claim for protection can delay the removal while a pre-removal risk assessment is conducted and a final decision is made. Trouble with gathering travel documents, identity confirmation issues, administrative deferral of removal, and temporary suspension of removal programs can elongate the process. You may want to pause this video if you're watching this on your own to read more about ADRs and TSRs. I have a few final thoughts on the subject of removal orders. A 30-day period seems like ample time, but it seems when you factor in the time needed to process and understand the order, tie up all loose ends in Canada, such as last month's rent deposits and personal property, the travel arrangements and preparations to reintegrate back into your home country, you will be hard-pressed for time. I can imagine some foreign nationals forget to check in at a CBSA office before boarding a one-way flight out of the country. What would be the proper protocol if you leave on time, but don't check in with the CBSA before leaving? I searched the Government of Canada websites, but I was not able to find a satisfactory answer. I will provide the answer in the form of a comment on this video when I find it. Next, appealing a removal order. The Immigration and Refugee Board is responsible for all appeals to removal orders, and judicial review for any decision goes to the federal courts. For now, we will focus on the first level of appeal. A permanent resident or a refugee with an ordered removal can appeal to the Immigration Appeal Division of the IRB. An exception to this rule is if the person was found inadmissible to Canada due to having committed a serious criminal offense, is or has been involved in organized crime, poses a risk to security, or has been in violation of human or international rights. If the appeal is made within 30 days of the removal order being issued, the order will be temporarily set aside while a member hears the appeal. The Government of Canada website states that these hearings are usually open to the public, which suggests that some high-profile or controversial cases may be held in private. While this is possible, they are most likely referring to the refugee hearings, which are usually private by default. This diagram illustrates the events around the process of a removal order appeal. After the hearing, the member may make one of three conclusions: allow the appeal, which sets aside the order, and allow the person to remain in Canada, or dismiss the appeal, which means the order will be enforced by the CBSA. Or, instead of either allowing or dismissing the appeal, the member may stay the removal order. This means the order will not be carried out temporarily while the IAD resolves to reconsider on another date. As an aside, this may be the worst outcome of a hearing because not only would you carry the uncertainty of your future in Canada for an indeterminate period of time, you must also regularly report to a CBSA office. The IAD may also cancel the stay at any time and announce a verdict. Inside a hearing room, you may find a scene resembling something like this. Be careful, though. If you walk in on an ongoing proceeding and see this, you might be barging in on a private hearing. Typically, you'll see the flag and name of the level of the courtroom in any hearing or courtroom or boardroom. A member's table sometimes has a border to prevent anyone from peeking at their notes. Directly across from the member is the appellant and their translator, if one is needed. To the left of the appellant is their counsel, and to the right, the counsel of the Minister of Citizenship or Public Safety. This person's role is comparable to the role of a Crown prosecutor in a criminal court. Behind the appellant are the witnesses, though if there were a larger room, seats for the general public would also be available there. The divisions of the IRB follow the same administrative tribunal process similar to that of a courtroom, but generally more flexible. The decision of the process will reflect Canadian law, Canada's international obligations, and Canada's humanitarian traditions. A person has the right to be represented, though at their own expense. This could mean a lawyer, immigration consultant, a trusted advisor, or family member. As an extra piece of research, I searched into whether this included paralegals. This is what I found on the Law Society of Ontario Frequently Asked Questions page. You may pause if you are watching this at home to read this, but essentially, a licensed paralegal has limited abilities in this area. A paralegal can represent a client at an IRB hearing and give legal services related to an IRB hearing to a client. But a paralegal cannot draft documents or provide services not relating to a hearing. This remains unchanged as of the upload date of this video. An opinion I have on this is that paralegals have been allowed this so that they can appear at a hearing instead of a supervising lawyer to allow the client to save some cost in low complexity cases, while also not allowing paralegals to overstep their lawyer peers in this field. But back to the procedure. Hearings are usually conducted in person. However, Section 164 of the IRPA allows for video conferencing. The Government of Canada website goes further and allows for telephone interviews and other similar remedies. Section 162, subsection 2 of the IRPA states that each division shall deal with all proceedings before it as informally and quickly as the circumstances and the considerations of fairness and natural justice permit. The Government of Canada reflects this when they say that hearings can be held by any means that allow for a fair hearing. There are some other notable aspects of the IRB. Due to the informal nature of the process, evidence is less restricted by technical and legal rules. Each division has its own rules over such things as time limits, documents, and obligations of counsel. The Ministry Council may, with permission from the court, call for leave to apply for the Federal Court of Canada for judicial review of an IRB decision that weighs against it, if eligible. But how does this relate to Lynn Pei Shen? It is imperative to Ms. Pei Shen that she remains in Canada. We will assume that the facts of her case remain the same, that she filed her appeal on time, and that she has been given her right to a fair hearing and everything that entails. One look shows that she did not include an important piece of paperwork, and no one in the hearing room disputes this fact. What allows for this particular case to make it to an appeal is that it is on humanitarian and compassionate grounds. What are humanitarian and compassionate grounds, though? The Government of Canada defines that people who would not normally be eligible to become permanent residents of Canada may be eligible to apply on humanitarian and compassionate grounds. They stipulate these grounds only apply to exceptional cases, and that they assess these applications on a case-by-case basis. Factors include how settled the person is in Canada, their ties to Canada, the best interest of any children involved, and what could happen if the request is not granted. A person cannot have more than one humanitarian and compassionate grounds application simultaneously. The board does not assess risks like persecution and cruel and unusual treatment. A person can't apply if they also have a refugee claim, and a person cannot apply if they have negative decisions against them in the last 12 months. This is called the one-year bar. In the hearing, we can anticipate that Ms. Pei Shen's counsel will ask about things such as her work, who she lives with, her education, and her son during her direct examination. In cross-examination, the ministry's counsel might ask whether she has a Chinese bank account and how much money is in it during cross-examination. Pei Shen's counsel may re-examine her afterwards and ask how much money is in her Canadian bank account for comparison. The member may interrupt at any point to ask supplementary questions, and will have a final opportunity to ask any additional questions to Ms. Pei Shen directly. Since there is a child involved, the member's main concern will be the well-being of Lynn's son. The counsel for Ms. Pei Shen will be allowed to call on other witnesses. Prime witness candidates may be Lynn's parents and other family members that she lives with. They can be relied on to give reliable and positive feedback in Lynn's transition into Canadian society. Of course, just like all other levels of courts, they may reveal information that is not beneficial to the case in cross-examination. Once all witnesses have been examined and the member has asked all relevant questions that came to mind during the hearing, the member may make one of three aforementioned decisions, and the session will come to an end. If Ms. Pei Shen's counsel was allowed, she will regain her permanent residency, and her family may be eligible to sponsor Pei Shen's child. If the order was stayed, she will remain in legal limbo until a conclusive decision was made. Let's presume a pessimistic outlook. Her appeal is denied. What can be done after that? Ms. Pei Shen can apply for judicial review. This involves two stages. In the first stage, she requires a lawyer to file an application for leave to seek judicial review within 15 days of the decision. Once submitted, the federal court reviews the documents in the case. Pei Shen's counsel must prove that there was an error in the decision or the decision was not fair or reasonable. I want to emphasize that this process of making a leave application is not a simple or quick task. If this summary I made from the Federal Court of Canada website is any indication, this can take more than 3 months to file all the paperwork back and forth. If leave is granted, then the application for judicial review begins. Ms. Pei Shen and her counsel will attend an oral hearing before the federal courts to explain why the initial decision was wrong. Lynn's removal order will be put on hold until the court reaches a decision. The federal court can either agree with the original decision or return the case to the IRB to be reheard. The federal court cannot reverse a decision. It is unusual for an IRB case to make it this far, but if Ms. Pei Shen is unsuccessful, but there is a certifiably serious question of general importance that can be raised, It's possible to appeal the federal court's decision and elevate the case to the Federal Court of Appeal, although we have drifted quite far from the scope of the IRB at this point. The only important thing to note is that if Ms. Pei Shen made it this far and succeeds, the judge has the power to order a new trial or hearing, or it can reverse the below court's decisions. The very last legal option that Lin Pei Shen has if she cannot gain leave for judicial review or appeal that decision is that she complies with the deportation order and applies for an authorization to return to Canada at the earliest appropriate convenience, and hope that her papers are appropriately filed and immigration is lenient over her past error. There is one last option, though it is not legal. Lin resides in Scarborough, adjacent to Toronto, a sanctuary city. In theory, she may attempt to reside in Toronto and evade deportation. However, there are 3 good reasons not to do this. First, as a legal student, I would never recommend this as an option. Being forced to live under the radar in fear of police and going without services that require ID checks, such as the hospital, is a dangerous way to live, not to mention illegal. Second, there is little for Miss Pei Shen to gain, and it is a huge inconvenience to her current lifestyle. She will not only live away from her son, she will live away from her family in Scarborough and twice as far away from her job in Ajax. Third, and most importantly, remaining in Canada in a sanctuary city would only elongate the time she's separated from her son and would rob them of any possibility of living together in Canada as a family. Hopefully, it does not get to that point, and Ms. Pei Shen can resolve this either with an appeal at the board level or filing an ARC form. Let's recall everything we learned in this video. First, we spoke about family sponsorships, who is eligible for sponsorship, the requirements of a sponsor, and the consequences of failing to file a sponsorship quickly. In the discussion about removal orders, we mentioned the 3 types of removal orders, the rules of deportation, what can delay a removal order, and what you can do if you are successfully removed from Canada but wish to return. Next, we discussed appealing removal orders and used humanitarian and compassionate grounds as an example for the cause of this type of action. We discussed the Immigration Appeal Division of the IRB, what IAD hearing rooms look like, and how a typical hearing might play out. We reviewed the rules and conditions of using humanitarian and compassionate grounds, and how that might alter the dynamic of a typical hearing. Then we discussed judicial review. We mentioned the stages, the lengths it may take to acquire leave of court, the possible decisions the federal court may make, and touched the concept of appealing a federal court decision to the Federal Court of Appeals. Last, we weighed all our case examples options and decided what the most realistic approaches were. That concludes this presentation. I hope you found the work of Christian, Angela, Jeff, and myself informative. Don't forget that this will be posted this week on the Humber Paralegal Facebook group, and that you can subscribe to this channel to be notified when the next legal educational video is posted.